Hello, friends. Very warm welcome to my business laws channel. I hope you must be staying healthy at home. So, last time, friends, in my first lecture, I took up the heading Consideration and Legal Rules as to Valid Consideration. So, in the second lecture today, I'm going to take up the heading Exceptions to the Rule, No Consideration, No Contract. So you all know, friends, as per section 10, any agreement which is made without consideration is not valid, it is void. But there are certain exceptional cases in which an agreement which is made in the absence of consideration is not void, it is valid. I hope you have all understood all these concepts, valid, void, okay? And if still you have any doubt, you can always write in the chat box in the comment section. So friends, moving ahead, the general rule of law is ex nudo pacto non oritur actio. That is, from a bare promise, no action can arise. A promise which is made without consideration is void and it is purely gratuitous. However, in the following cases, which I'm going to take up, friends, an agreement which is made in the absence of consideration is not void, it is valid. So first exception is natural love and affection. Now this is stated under section 25, subsection 2, that in any agreement which is made on account of natural love and affection, if it satisfies these four conditions, even if it is made in the absence of consideration, but it is valid. Now the question arises, which are these four conditions? The very first one is it is in writing. Second is it is registered under law. Third is it is made on account of natural love and affection. And it is made between the parties standing in a near relation to each other. So first point is very clear, friends. It should be in writing. The agreement must be in writing. It is registered under the law. Unregistered agreement, here, the contract will not be valid. It should be made out of natural love and affection. There should not be any quarrels, any disagreement. Okay, it must be made out of natural love and affection. Then it is made between the parties standing in a near relation to each other. So now the question arises, what is the meaning of this term that parties standing in a near relation to each other? Nearness of the relationship can be inferred between friends or, among those persons who are related by marriage. Now, it cannot be inferred among friends. The parties must be related by blood, brothers, sisters and all, or, the parties must be related by marriage. So nearness of the relationship cannot be inferred among friends. Now here, I would like to take up case law, which was Rajalakhi versus Bhutnath Mukherjee. Husband, promised to pay a certain amount to her wife despite, there's consistent quarrels and fighting. And later on, he never paid any amount to his wife. And wife filed a suit against the husband, and it was held in the court of law, that husband was not liable to pay the amount because all conditions were satisfied. Agreement was in writing, it was registered, and the husband and wife, they are related by marriage, but it was not made out of on account of natural love and affection. So friends, all four conditions must be satisfied. Then only the agreement which is made without consideration is valid. And another point I would like to now coming to the second point, which is agreement to compensation for past voluntary services. Any agreement where voluntary services have been rendered by the promisor without being requested by the promisee, then in that case, there is no consideration moving from the other party, but still this agreement will be valid. But again, friends, as per section 25, subsection 2, there are certain requirements which must be met. The very first point is the service must have been rendered on voluntary basis and not at the desire of the promisor. So if it is rendered at the desire of the promisor, then it will be covered under section 2D, but not under section 25(2). Say for example, A has taught B's son without being requested by B person. And later on, friends, B promises to pay here the amount to A. Here, there was no consideration which was there from B to A, because voluntary services were rendered here by A to B. A did not expect anything because no request was, made by B to A. You come and teach my son. So voluntary services were rendered by him, and later on, subsequently, B wants to compensate A for his past voluntary services. Then this promise will be enforceable under section 25, subsection 2. Next is the service must have been rendered for the promisee. Service must have been rendered for the promisee. Durga Prasad versus Baldev is leading case here, where Durga Prasad constructed the market at the desire of the collector of the district. He did not construct the market at the desire of the shopkeepers. So I hope you must be clear about all these points. Next is the promisor must have been in existence when the service was rendered. Any service which is rendered by the promoters during the promotion stage of the company cannot be brought under this exception, as the company was non-existent at that time. There should have been intention of the promisor to compensate the promisee. A main intention of the promisor should be to make good the loss or to compensate the promisee person. The promisor must be competent to contract at the time when the service was rendered. So you all understand the meaning of competency to contract. The person must be competent to contract at the time when the service was rendered. And next is the promise must be given to a person who has rendered some services for the promisor. So promise must be given to a person who has rendered some services for the promisor. So otherwise, that agreement will not be valid. Now coming to the third point, which is promise to pay a time-barred debt. First of all, friends, I would like to explain what is the meaning of time-barred debt. Under the Law of Limitation Act 1963, the debt becomes time-barring debt after the expiry of 3 years. Say X owes Y 10,000 rupees, and he has borrowed this money for a period of 1 year. And after 1 year, he has not made this repayment of debt to Y person. And now Y has a right, after this expiry of 1 year, up to 3 years period, he has a right, he can file a suit against the debtor. And if he defaults, if he does not file a suit against the debtor within a period of 3 years, after 3 years, this debt will become time-barring debt. That is, a creditor will be losing his right to file a suit against the debtor. So friends, I hope that you must have understood this point. But there are certain conditions which must be satisfied here. This promise must be in writing, and it should be signed by the debtor or his authorized agent. Say X owes 10,000 rupees to B, and B has filed a suit against the debtor after 3 years period. And then he was told that this debt has become time-barring debt. Now you have lost your right. Now still after 3 years, friends, the X person debtor wants to pay 5,000 rupees or 6,000 rupees, the whole amount or part of the amount to B person. And he puts this agreement in writing. The agreement is signed also by him or by his authorized agent. Then this promise can be enforced in the court of law. So friends, all the points I have explained in my example, it must be in writing, promisor himself must be liable for the debt. Then this promise can be to pay whole amount or part of the amount. The promise must relate to the debt which could not be enforced by the creditor because the limitation period had expired. One more point I would like to add, friends, the promisor person, should himself or herself should have been liable to pay the debt. Any debt, time-barring debt of the husband after his death, the wife gives a promise to pay this debt, then this promise cannot be brought under this section 25 subsection 3. Now, first three exceptions are very, very important. Now, fourth point is completed gift. Any gift which is made, by one person to another, donor to donee. Okay, this is without consideration, but it is not void, it is valid. But there are certain points which must be kept in mind. First is, what is the capacity of donor? Intention of donor to make gift, intention of possession of gifted property, acceptance of gift by the donor. It is acceptance of gift by the donor which will make the gift complete. Say for example, friends, A has given watch to B on his birthday. So B is not going to pay anything to A. Still, the ownership will pass from A to B. Now, this will be complete only, gift will be complete only when B accepts this watch, gift from A person. Okay, all these points, are worth considering whenever this exception is answered. Now, coming to the fifth point, which is contract of agency. Now, any agreement as per section 185, when the contract of agency is created, then no consideration is required. Say P, principal appoints A as his agent. When he appoints as his agent, then no consideration is required. Still, the contract of agency is valid. Then remission by the promisee of the performance of the promise. Any remission means to accept lesser performance than what is due under the contract. X owes 10,000 rupees to Y. Now, he borrowed this money for 1 year period. After 1 year, he has not paid this money. Then in that case, friends, and he can pay only 8,000 rupees. Now, B says, okay, you pay me 8,000 rupees. I will accept in full and final settlement. Then also, friends, this agreement will be valid because lesser amount has been accepted by the creditor from the debtor. The seventh is contribution to charity. Any promise made under a contribution to charity is not enforceable because it is made in the absence of a consideration. But there are certain cases where a person promises to contribute to charity and on the basis of strength of the promise, the other person undertakes certain liability. Then in that case, here, the promisor should be held liable to the extent of liability incurred, not exceeding the promised amount of subscription. So there are two case laws here, Abdul Aziz versus Masoom Ali and Kedarnath versus Gauri Muhammad. Friends, in one of the cases, Abdul Aziz versus Masoom Ali and Kedarnath versus Gauri Muhammad. Kedarnath versus Gauri Muhammad, promise was given by A to the Muhammadan, to the Pradhanji of temple that I will be contributing 100 rupees. And then, on the faith of the promise, nothing was incurred. No liability was incurred by Pradhanji of temple. Then in that case, Pradhanji of temple could not recover any amount from the donor. But in the second case, Abdul Aziz versus Masoom Ali, promise was given to contribute 500 rupees towards the rebuilding of mosque. And some liability was incurred by the secretary of the mosque. And later on, donor refused to pay the amount. It was held in the court of law that donor was liable to pay the amount to the extent of liability incurred. So friends, you must be very clear about this point, contribution to charity. Then contract of guarantee. In a contract of guarantee, consideration received by the principal debtor shall be sufficient consideration for the surety. So friends, when contract of guarantee is made, now there are three parties involved in the contract of guarantee. One is the debtor, second is the creditor, third is the surety. Surety gives the promise to the creditor that debtor will discharge his liability. And if he does not discharge his liability, then his liability will be discharged by the surety. But friends, surety is not going to get anything from the debtor. Just he wants to help the debtor person. So here there is no consideration. Okay, still surety will be held liable. So the contract of guarantee will be valid. Provided, at the request of surety, Creditor has lent that money to the debtor. That is the sufficient consideration for the surety. So the last point is gratuitous bailment. Gratuitous is without consideration. No consideration is required in case of gratuitous bailment. Say A and B both are friends, and B person makes a request to A to lend his car to him for 1 or 2 days, or say for 2 days. Now he has to organize a trip, and A lends his car to B for this purpose. And now A is not going to charge anything from his friend. Here, friends, this contract will be valid. Okay. Or A and B both are friends. A has qualified CA exam and B has to appear for the CA exam. And B requests A to lend his books to B person or notes to B person. And A gives notes or books to B person as requested by B. And here also, friends, A is not going to charge anything from B. So what is bailment? Bailment is the delivery of goods by one person to another, where the goods are delivered for some purpose. So when the purpose is over, the goods are to be delivered by the bailee to the bailer. The person who delivers the goods is known as bailer, and the person to whom the goods are delivered is known as bailee. So this bailment contract may be with consideration or without consideration. So friends, in my today's lecture class, I have talked about all these 9 exceptions. Agreements made on account of natural love and affection, compensation for past voluntary services, promise to pay time-barred debt, completed gift, contract of agency, remission by the promisee of the performance of the promise, contribution to charity with 2 case laws, and then second last point, contract of guarantee, and the last was gratuitous bailment. Very important question from examination point of view. What do you mean by the term consideration? And state the exceptions to the rule, no consideration, no contract. So define the term consideration as per section 2D of ICA 1872, and then come to the various exceptions. Write exceptions, explanations along with the examples or case laws. Because in mercantile law paper or business laws paper, cases and examples are must. So friends, this is all in today's lecture class. I hope you will like this content, and do like my videos, subscribe to my channel, and press on the bell icon so that you can get notifications of my subsequent videos. Okay friends, goodbye, see you. We'll meet soon, and I will be sharing more videos. Okay friends, goodbye.